Hey, it's James, Father's Rights and Resources, hashtag how I got custody. This is my video on the rules of evidence. Many of you have probably heard hearsay. You've seen in movies where they, lawyers object. Objection hearsay, objection that's irrelevant, objection foundation. And you see that, but it's kind of subtle and nobody really talks about it. Nobody really knows in depth what that means. So when I go to court, I object to anything that's inadmissible in court. And I'll give you this illustration so you understand. If you file if you're charged with murder and they find a body in the trunk of your car, but the cops didn't search and seize your car with a warrant, that's a legal search and seizure. Like they pull you over, like they might know somebody's in the mafia and they're monitoring them, they're trying to get them, and they get them with the taillight out and they pull them over and they say, let me search your trunk. Well, they don't have probable cause unless they smell the funk of a dead body or something like that. So if that guy goes on trial for murder, before the hearing starts or before the trial, they can motion to suppress evidence or exclude evidence. And if they find that was an unconstitutional search and seizure, even though everybody knows in the hearing that dude is guilty of sin, they'll throw it out, because if they allow that in that case, then they'll allow it in other cases. And the Constitution is there so everybody gets a fair hearing, even if a bad guy gets off. So in that situation, if they move forward with trial and the prosecutor says, well, we're going to try and get him anyway, even though we don't have a dead body, we'll try and get him on circumstantial evidence. And then when they got him on the stand during trial, they say, hey, but we found a dead body in your car, didn't they? Or the cops found it, didn't they? The defense attorney will say, objection, we've excluded that from the evidence. And the judge might find that prosecutor in contempt of court, throw him in jail, punish him, or something like that. Or, well, they'll probably declare mistrial too, because you don't turn to the jury and say, now I want you to unremember or strike that piece of evidence from your mind. That's why they do a pretrial hearing before the jury comes out or the jury is selected. They try and get the evidence excluded so it's not brought up. It's thrown out of court, so that makes it inadmissible. That means it can't come into court. It's not admissible. So what happens in family court a lot of times, you might say in the middle of a hearing, like this happened in my own case a little bit ago, I object because the attorney is talking about hearsay, and the judge says, no, you wait until your turn to talk. If it's inadmissible, the evidence rules are like a screen door to keep out the bugs. You don't let it in and let the person continue to talk and argue and then go ahead and wait until it's your turn and say, oh, wait, I want you to unremember what you just said and what muddled around in your head for a while, what built a nest on your head. It's not allowed. Why is that? Because inadmissible evidence is unfair. Because anybody could say what somebody else said, or hearsay is not admissible because it's not reliable. So when a judge or commissioner tells me you have to wait until your turn, say, no, you can't allow inadmissible evidence in at all. Not now. You can't wait until later after you've meditated on it and thought about it seriously, because it's not admissible. They slipped it in. It's not allowed in. You have to block it before it gets in. That's part of unbrainwashing the judges and commissioners who do stuff however they want to do it. They're not allowed to bring it in. They're cheating if they bring it in. You don't say, in basketball, the guy picks up the ball and starts running and traveling, or somebody in Monopoly, they roll a 5 and they move their thing 12 spaces. You don't say, well, let's wait until my turn and then we'll move them back. No, they're cheating now. You stop the cheating when the cheating happens. Okay? You have to stop it before it happens. So, the evidence rules, there's federal rules of evidence. You can Google rules of evidence in your state and find them yourself. I Google rules of evidence Washington or federal rules of evidence, and the federal rules are correspond to the same number. Here's the evidence rules that I care about. ER 602 is personal knowledge. It says nobody can testify to anything unless they have personal knowledge of a matter, which means they saw it with their own eyes. Hearsay is not admissible. If I say, oh, I heard that Joe killed Bobby at 7-Eleven and I was at Burger King. I heard that. That's hearsay. I heard somebody say it. So I don't have personal knowledge. my friend has personal knowledge because he saw it. So that person that needs to be a witness. So I would have, somebody can object to me saying what somebody else said because I don't have personal knowledge. Or if I wasn't there and I just say, yeah, this person killed them, or in a family court case, the mother says, yeah, the father's home is unsafe and the child's up late at night. If she wasn't there to witness it, she can't testify to it. Objection, personal knowledge. I give the title of the evidence rule and I stop it from happening. Objection, personal knowledge. So basically I sit there and think, okay, when they're talking, were they there? Were they there? Were they there? An attorney can't talk about stuff unless the witness talked about it in their declaration. So a lot of times the mother might say, you're an alcoholic. And the attorney says, the father's an alcoholic. And we also believe he snorted cocaine in high school and maybe he relapsed. If he adds to the story, that attorney is testifying. Attorneys are not allowed to testify under the rules of professional conduct in most states. But they also don't have personal knowledge, so they're not a witness. So if they try and testify, I say, objection, attorney's testifying. And then I'll say, you either get rid of his testimony and shut him down and stop him, or you have to dismiss him as an attorney because he's acting like a witness. He can't do both. There's also ER 402, relevant. Anything that's not relevant is not admissible. If they start talking about when I was in 4th grade and I got in a fight on recess and they're talking now about my parenting, objection, irrelevant. What does that got to do with this? And then ER 403 is even better because even if something's relevant, if it's a waste of time, if it's a needless presentation of cumulative evidence, if it causes possible unfair prejudice, oh yeah, the father got in a fight several times on recess, or his previous girlfriend didn't like him. That's to make me look bad or prejudice me, and it's unfair. So I object to that. Objection, unfair prejudice. Objection, irrelevant. Objection, ER 403. And if they might say, well, what are you talking about? And then I'll say, that's a needless presentation of cumulative evidence. We're going to have to go into an entire book on that issue. It's a waste of time. Why don't we talk about my parenting and the stuff that's relevant, Your Honor? So 602. 702 is, 802 is hearsay. I already went over that. There's a bunch of exceptions to the hearsay rule, like if somebody screams an excited utterance, like if you step on somebody's toe and they go, oh, I'm going to kill you, or they react like that, I assume that's admissible because it's such a vivid memory, or an excited utterance or excitable utterance. It's so vivid that you can probably remember it accurately, so they allow for that. So if the mom has a boyfriend, say, I'll kill you, mother effer, or whatever, say, well, her boyfriend threatened to kill me. She lives in a violent home, which is toxic to the child. I should have full custody. And her attorney says, objection, hearsay. No, that's the exception to the hearsay rule. That's an excited utterance. ER 702 is expert testimony. If the mother tries to say I have a psychological disorder, objection, she's testifying like an expert. Does she have a psychology degree? Did she evaluate me with all of the markers and testing that's required in the profession nowadays? Or where in the DSMV did she get that? Objection, expert testimony. If somebody tries to say psychological disorder, anger management, I have a whole video on anger management down below, which is, I would question somebody on the stand. Okay, you're a guardian ad litem, you see you have an anger problem. Okay, is anger bad in and of itself? Are you allowed to be angry sometimes? If she says no, say, okay, so a dad shouldn't be angry at a pedophile who molests and rapes his daughter? That would be stupid. So you say, okay, so anger is okay, but where's the dial where it crosses over and it's too much? Then you ask them, or I would ask them, okay, how do you measure when anger goes too far? Oh, it's a discretionary decision with you, and you have a history of mental health issues. You had a boyfriend. Did your dad beat you up? Are you skewed in your? Where do you get where's the scientific information on that? Objection to this testimony isn't relevant because they're testifying like an expert, and they can't possibly have that expertise. So, I stop all these. Now, there's case law that says that the whole purpose of the evidence rules is for a fair hearing, and when the evidence rules are violated, it's not a fair hearing. We don't have a fair hearing, you don't have due process. So I tie case law into that with those evidence rules. So, in short, the ones that I like are ER 402, and all you have to do is Google it. And if your attorney is not objecting to stuff in court like this stuff, then your attorney's not doing their job, and they're committing malpractice, and they're incompetent. ER 402, ER 403, ER 602, 702, and 802. And then also, a judge is not competent to testify, so judges can't say, oh, well, I've seen cases like this, and this is a typical case of someone with an anger management problem. That's where they start testifying. Objection, ER 605 or 609. You're not competent to testify. So those are the objections I make and how I make them on the record or on paper also.